Hi, good evening, council members. My name is Brooke Anderson. I'm with the East Bay Alliance for a Sustainable Economy. First, I just wanted to thank the city for its defense of Measure C and its support for the rights of workers who filed administrative complaints with the city. We really appreciate the city's commitment to fairness and to living wages for workers. And tonight, I wanted to address the regulations and procedures to enforce Measure C.
Pardon me, ma'am. That is an agenda item, and you're able to speak to it on the agenda item.
At what point
when
would
it
that
comes
come
up on the
When
agenda.
it's on the agenda.
Okay, and I'm not allowed to speak to it during citizens'
No,
input?
this is for items not on the agenda.
Got it. Thank you.
You're welcome. So we have several people here from on the Measure C issue, and I would like to move it up on the agenda. Is that all right with everybody on the council?
Yes.
All right. That is which item is
7A.
that?
7A.
7A. It's a resolution of the City Council adopting regulations and procedures implementing Measure C. Mr. Biddle.
Thank you, Mayor Davis. Before you, and I provided on your dais a revised version, which I did make copies of earlier, and I also did email the revised version to some of the hotels and other interested parties. What I would then propose to do is to walk through these revised regulations, unless you want to, and I was going to do it in some detail, unless you would rather have me approach it otherwise and open it up and hear if there's any comments and ask questions.
Yeah, why don't you do that?
Well, why don't we open it up to any comments from the audience, and then if there are any specific areas of interest, the council can zero in on them. Was that acceptable to the members?
Yeah.
All right. Any members of the audience wishing to speak on Measure C, these rules and regulations?
Just before we start, I will just indicate that I did provide you a copy of a letter that was provided by eBase, and they had some issues that I imagine they're going to speak to as well later. Excuse me.
There's also a letter from Woodfin Suites here.
Okay, I haven't.
If I may, I would like to read that letter.
All right.
Thank you. This is a letter that I delivered to Mayor Nora Davis and copied all of the honorable council members. On behalf of Woodfin Suites Hotels, I would like to register and enter into the public record my strenuous objection to the hurried manner in which the regulations and procedures impending Measure C were published and distributed prior to this evening's council vote. The current draft, the first our company has had the opportunity to review, was transmitted via email and received at our offices at 5:59 p.m. on the afternoon of Friday, January 12th. A circumstance that, in light of Monday's holiday, allowed us just one business day to review a document of considerable length and technical complexity. I find it frankly unconscionable that Council would fail to provide organizations directly impacted by Measure C with a reasonable period of time to review, consider, and comment on these regulations prior to their being put to the Council vote. I'm confident that Council members share our company's desire to see that any regulations governing local business are carefully crafted, meticulously reviewed, and effectively implemented. As such, I would respectfully request that the Council delay action on the governing regulations and procedures until a working session between members and local representatives can be convened to review specific elements of the proposal and their attendant repercussions. For the record, we at Woodfin continue to assert that Measure C is, in its current form, is a flawed piece of legislation that unfairly burdens suite-type hotels, which remain highly popular with business and leisure travelers alike, and as such constitute a vital component of the Alameda County business community's lodging base.
Any questions? Thank you.
I guess the question would be, is there any harm in letting them go over the regulations with the staff before we, I mean, I'm not trying to delay implementation, but I think he raises a point, so.
Well,
It will delay it. That's the whole issue. I mean,
Well-
I mean, I don't know if they can go off into a room and do that right now, but I mean, the longer
not
these
gonna
things
do-
aren't put in place.
Okay.
Well, I mean, to the extent that the Woodfin Hotel honors the provisions that the council adopted in its urgency ordinance to provide protections to some of the workers who have filed complaints relative to noncompliance with Measure C, then I don't perceive that a delay is going to be a harm to them, because of the timeline in terms of the city having to then commence the investigation is sort of stayed, and they likewise are continued to be obligated to keep them on the payroll during that period of time that we're undertaking our investigation. So, because the triggering point in that urgency ordinance was the adoption of these regulations. So if we put it off another 2 weeks, then there's no harm to the employees from my perspective.
My problem with the delay is that one of the things that we're asking a judge is to grant a motion for preliminary injunction. Why? Because from the city's perspective, it's to put things on hold, maintain the status quo until the city decides if there's basis for the allegations. We are not putting this, we're not punting the substance of these complaints to the Superior Court. And for us to delay the implementation of these regulations means that at the January 23rd hearing, our council has to tell the judge that the city doesn't even have its regulations in place, which I think looks bad. I think that we should be able to tell the judge, look, we at the last city council meeting, the city council adopted these regulations, and now the city staff is in the process of investigating them, and judge, we're asking you to order that the status quo be maintained so that the city can determine the validity.
Well, certainly we would go before, just to respond to that, to the extent that became an issue of the court, we would certainly make it clear to the court that the reason that we decided, that the council decided to continue the consideration of it was at the request of the representative of the Woodfin Hotel. So I think they would be hard-pressed to, on one hand, argue that we're not proceeding, and then because we've delayed it at their request.
I guess I think we have a better leg to stand on if we at least gave them the opportunity to review the regulations before the implementation, that the court might see it to our advantage.
Let's see if there are any other people who'd like to speak to this. Thank you, Mr. McIntosh.
Yeah, if I may, Mayor, just before Hugh, I said last time, you're here doing a job, and I appreciate that. And we've always had a great relationship with businesses in this town, and I've been a very pro-business person, and I campaigned against Measure C. That was before you were here, because I still believe it's not the proper thing that cities ought to be doing, but it was passed by the voters, and so our job is to enforce it. And I just want to say, I understand the company's concern about the time to review these regulations, but if we're going to start throwing around words like unconscionable, I just want to say that the fact that the hotel's actions put this city in a place where we had to run off and try to get a restraining order to stop what I believe were unconscionable actions is really a breach of the relationship that this city has had with the Woodfin Hotel in the past. So if that term applies here, and I understand the frustration with the short timing on these regs, but I hope you also understand the frustration we have and the very tough position that Woodfin has placed this city council in relative to the workers. And I want to make that real clear, that I think that we have been backed into a corner that I'm not comfortable being in, and I don't think, frankly, any of that was necessary.
Good evening. Pardon our earlier confusion about when the appropriate time to speak is. Brooke Anderson. I'm from the East Bay Alliance for a Sustainable Economy. I'm here tonight to address the proposed regulations and procedures to enforce Measure C. We believe, and also I believe you have a copy of a memo that we've written on the subject. We believe overall that the regulations contain a fair and reasonable process to go about the enforcement of Measure C, with two exceptions. The first is the August 2006 start date, and the second, a lack of a worker appeal process. I'd like to address the first of these, that the city will not consider violations of Measure C that happened before August 11th, 2006, in either the permitting or the investigation of worker complaints. So first, this seems to undermine the city's successful effort to defend Measure C against court challenges. Two hotels challenged Measure C in court and then requested a preliminary injunction against the law. The judge ruled against the injunction, which means that the hotels are required by law to comply with the ordinance back to the start date of December 2005. The city spent taxpayer money to defend the ordinance, and we're glad that you defended it. But if the city ignores non-compliance of the law for the first 8 months after the effective date, then taxpayer money spent to defend the ordinance has been wasted. Further, we're concerned that this sends the wrong message to other Emeryville businesses that if they can forego compliance with city law by initiating litigation against the city and requesting a temporary restraining order, even if they have little chance of being granted that kind of a restraining order. Second, by settling on an August 2006 start date, you're giving the hotels what we believe is a special reprieve. And the hotels knew that their legal challenge could fail and that they would be mandated to comply all the way back to December 2005. And the industry standard for businesses is to make plans to comply in the event that they're not granted an injunction. For instance, with a local example, Skates Restaurant, it challenged the Berkeley Living Wage Ordinance many years ago in federal court, and they paid the difference between their existing wages and what the wages they would be required to pay under the Living Wage Ordinance into an escrow account for 2 years during which the trial proceeded. This money was then ultimately paid back to employees when the restaurant's lawsuit failed. Emeryville hotels could and should have done likewise in preparation for a failed legal challenge, and so there's no reason to let them off the hook by changing the start date to August 11th. Lastly, Measure C afforded Emeryville hotel workers certain rights dating back to December 2005. And while many of these workers are owed thousands and thousands of dollars in back pay in between those two dates, and they deserve to have this considered in deliberations about the regulations. And for the sake of the city who defended the law, the residents' taxpayer monies that went into that defense, and then workers whose rights are at stake, we'd urge you to strike from the regulations the clause establishing August 11, 2006 as a compliance start date. And regarding possible delay of discussion around these regulations, I would encourage the council to ask the Woodfin whether or not they intend to abide by the 90 days ordinance that was passed several weeks ago that would provide protection to workers who filed complaints and give time for the city to investigate those complaints. And if the Woodfin intends to abide by that, we would consider being okay with a possible delay. Thanks.
Is this on?
Buenas noches.
Good evening. Can you hear this?
It sounds like it's like, maybe we can ask the recording person, is it coming across?
It's on,
Yeah.
yes.
Okay. Thank you.
It's on.
Buenas noches, señoras y señores. Como ustedes saben, somos un grupo de trabajadores del Good Feng Shui Hotel.
Good evening, ladies and gentlemen. As you know, we're a group of workers from the Woodfin Suites Hotel.
Hemos estado viniendo para ser escuchados, como ustedes ya están enterados,
We've been coming to be heard before you, as you know.
de nuestros problemas y sabemos del apoyo tan grande que nos han brindado todos ustedes.
And we know of the great support that you've provided for us.
Venimos una vez más a pedirles, por favor, más de su ayuda.
And we've come once again to ask you for help
Para que se haga justicia y se pague lo correspondiente, para que se pague lo correspondiente desde que entró en efectivo la medida C.
And we're asking you to help us arrive at a just solution where the money is paid that is owed going back to the beginning of Measure C.
Que como ustedes saben, esta medida fue aprobada en diciembre del 2005
As you know, this measure was approved in December of 2005.
y no como se quiere hacer de solamente contarlo desde agosto del 2006.
And not this past August, as the proposal suggests that enforcement should begin.
Esto para nosotros es algo muy serio,
This is something very serious for us
porque está en juego nuestro duro y difícil trabajo que desarrollamos en este lugar.
because what's at play for us here is a year of long, hard work.
En este año que elaboramos, hemos sacado adelante la empresa del hotel
In this year, we've been moving the business forward with our work.
y nos gusta el trabajo y lo hemos sacado al 100%.
We like our work, and we've been putting 100% into it.
Y si es algo que por ley nos corresponde, queremos que así sea.
And if there's something that is our right under the law, we want it to be that way.
No venimos a pedir algo que no exista o que nosotros lo hayamos inventado.
We're not asking for anything that doesn't already exist or anything that we've invented ourselves.
Y si es por ley que nos corresponde, de favor les pedimos que se haga efectivo.
If there's something that's our legal right, we want it to be effective.
Que se cuente el tiempo desde que correspondió a ejercerse la medida C en el año 2005.
So we're asking that you consider violations of the law going back to when Measure C was first went into effect in 2005.
Y no como se quiere hacer ahora, solo de agosto para este momento.
And not only since last August.
Siendo que el 2005 fue un año difícil para nosotros,
Since 2005 was a difficult year for us,
porque limpiábamos 16 suites, que como ustedes saben, no son cuartos sencillos.
because at that time during that year we were cleaning 16 suites a day, which, as you know, are not just rooms.
Y aún así, con orgullo y con mucho esfuerzo, sacamos el trabajo.
And you know, with great effort and with pride, we got that work done.
Sin en cambio, aquí seguimos y seguiremos trabajando hasta que se nos permita y seguiremos cumpliendo
So we're and we got that work done, and we're continuing to work, and we will continue to work as long as they let us, and we keep on doing what they ask of us.
pero por favor, queremos que también se nos cumpla a nosotros.
But please, we're asking that they also give us what's our due.
Esto es una prueba más de que nosotros somos gente de trabajo y con responsabilidades.
This is one more proof that we're hardworking people with responsibilities.
Y solo les rogamos atiendan nuestras necesidades y nuestras opiniones.
And we're just asking you to pay attention to our needs and our opinions.
Esperamos que sean justos e investiguen a fondo esta situación.
We hope that you will be just and investigate the situation.
Porque de esto esperamos ser recompensados a lo que nos corresponde por el trabajo que realizamos los housekeeping.
Because we want to be compensated for the work that we from housekeeping have done.
Gracias.
Thank you very much.
Can I ask a question? Mike, does the city have the legal ability to delay implementation of a voter-adopted law?
Well, to the extent there were, I don't want to get too far into, discussions that are probably more appropriate in closed session. But to the extent, there was a challenge filed and there was a motion for an injunction pending for some period of time, that was sort of the basis upon which the suggested further resolve, the last resolve on the last page was presented, was that there was sort of a a holding period or holding pattern as related to the city's implementation of it. And while I appreciate the comments of some of the workers, there's also trying to be somewhat fair to the hotels based on what they observe to be, the city's position as to its implementation.
Ruth?
Could the staff explain why the August date was picked?
Well, as I said, I don't really want to get into disclosure of closed session discussions, but it reflects back on sort of the direction of the council as it related to that federal lawsuit litigation.
I also had some comments to make on a different subject related to this. Should I go ahead with that?
Go
now,
ahead.
or- Okay. So good evening. My name is Sarah Knorr. I'm from eBase. So we want to thank Mr. Biddle for developing these proposals. I think they look great overall, but I just wanted to point out one other change that's very important to the workers. So as written, this proposal puts city staff in charge of decisions about permitting, about whether to grant or deny or attach conditions to a hotel operating permit. So that means the staff's also going to be responsible for investigating worker complaints. And if they find that a worker complaint does have merit, they can use the permitting process to correct that, for example, by attaching a condition to the hotel's permit sufficient to correct the problem. And the proposal also allows hotels to appeal the decisions of the city staff in this area. So, if the city staff determines that a condition should be added to the permit, they can appeal that. And when that happens, they're given a hearing before the full council. They're given the opportunity to bring in witnesses, bring in legal counsel, and to tell their story, both to the council and to the general public, which I think is fair enough. It's a serious issue, and they should have the chance to express their views. The issue I have is that if the workers disagree with the staff decision in regard to these complaints and to the permitting, they have no recourse at all under the proposal. They have no possibility to appeal. So they have no ability to bring their concerns either directly to the council or to the public at large. So just to consider how this would play out in the scenario that we have now, so some of the Woodfin workers, as you know, have filed complaints alleging that they were cleaning more floor space than they were supposed to and they weren't paid appropriately, and that the hotel suspended and sought to fire them for their support of Measure C. So if the staff investigates and finds that these allegations are true, they could attach a condition to the Woodfin's operating permit that would be sufficient to remedy that. And if they do that, the hotel is going to be able to appeal that decision, bring their case to you, bring in their witnesses and their lawyers, and get a fair hearing. But on the other hand, if the staff decides, no, these complaints don't have merit, so we're going to go ahead and grant a permit to the hotel unconditionally, the workers would have no chance to appeal. You guys would never have the chance to hear their side of the story. So this, to me, seems unfair on the face of it. There should be one standard of justice that applies to everyone. And I don't want to suggest that the city staff would ever make a mistake in their permitting decisions, but if we're going to give hotel managers the opportunity to disagree with staff and to bring their concerns directly to the council, I think a housekeeper is entitled to the same level of respect. It's the same principle where a zoning decision could be appealed by a business or it could be appealed by a neighbor that's affected by that decision. In the case of these workers, their jobs are on the line, so they certainly have as great a stake in the situation as anyone. So I just suggest changing the procedure to allow workers the same appeal rights when their complaints are not acted on as a hotel has when the complaints are acted on, just as an issue of fairness. And in regards to once again, to the issue of whether to begin in August or in December 2005, I think it's clear that there was things were up in the air legally, but I think we should look at who initiated that uncertainty, right? It was the Woodfin and the Sheraton that filed that lawsuit that created that uncertainty. The workers never did anything to create that level of doubt. It was definitely the hotels that took the initiative to put that situation in play up in the air. So when we look at someone taking a loss here of over $100,000 by our calculations of which is the amount of money that should have been paid to the workers for cleaning over time between December and August, someone's got to take that loss, right? It's either going to be the hotels or the workers. And since the hotels were the ones that created this situation of uncertainty, and I think did so at their own risk, there's no reason why the workers should have to lose that money that they're legally entitled to. It's not their fault, and they really need the money. So thank you very much. As far as, whether these comments become relevant this session or next session, I think, again, as long as the Woodfin plans to abide by the emergency ordinance and not fire workers during that time, it's whatever you guys think is appropriate is fine with me. All right, thanks very much.
Members of the council?
I think that the two issues, well, the first thing before we get there is does the city council want to delay this? I'm prepared to not delay it, but I think that should be decided preliminarily before I get into the substance of my comments.
Well, is the hotel going to maintain the status quo if this is continued?
Well, the hotel does not have the greatest track record, so
But I mean, if they represent here that they're going to do that, I would assume that that would be what they're going to do. I mean,
okay, well, they also represented at a prior meeting that they were forthwith going to produce the data that the city attorney's office requested, and they did not.
Well, we received that January 5th, I believe. Forget what the Monday was, but it was a
I'm
week
okay
ago.
with the delay. I mean...
I'm
given-
okay with the
given
delay, too,
position-
because I think it is a rather complex document. There's some serious issues here, and if the city attorney assures us that no one is going to be harmed by a delay, I would entertain a motion to move this to the first February meeting. Do I have a motion like that?
Well, we haven't
No one will be
gotten,
harmed?
I'd like to hear from Mr. McIntosh.
Yeah, I think that's more appropriate.
Thank you for the opportunity again. Yes, we did provide the documentation to the city, as Michael Biddle stated, and that was done on the 4th of January. I met with Margaret O'Brien in your boardroom here, went through any questions that she may have had, and I've spoken to her on a couple of occasions since to clarify a couple of matters, and I presume she's moving forward on that now. Certainly, we will comply with the ordinance, and the workers will be safe until this is resolved, and if you would grant a slight delay, we would certainly be very appreciative.
My understanding is that the workers were returned to work but not at full time. Is that the case?
Well, the workers have come back to work in a period of low occupancy, and as we all know in the hotel business, housekeepers' hours are based on the level of occupancy in the property, and our occupancy is down right now due to the seasonality of the business.
So are you representing that a year ago the same thing happened, that the workers were not working full-time during a low occupancy period?
I wasn't there a year ago, but that is the trend in the hospitality industry, that the maids' hours are totally relevant with the occupancy level in the hotel. So if the occupancy level is down, the number of hours that are available to distribute to the workers is down as well.
Is it the case that you hired replacement workers?
We didn't hire replacement workers. We hired workers that we needed to complete our complement of staff.
Are any of those workers still employed at the Emeryville location?
7 of them are, and we have taken the largest pool of hours and distributed them amongst the 16 complainants, and the residue of hours, if any, are going to the other 7 associates.
I just think we come out of this better when we give them a fair opportunity to
Well,
review
is that
it.
a motion
Yeah,
to?
yeah.
All right, do I have a second on that?
Yeah, I'll second it, but then we can still get into the substance of these other...
Yeah.
All right.
Sure.
Let me ask my colleagues one thing.
Thank you.
I went through it pretty carefully, and I'm prepared to delay, but I wonder if it would be helpful to at least go through the substance, and maybe not implement now, but just to go through it as well, because it's fresh in my mind right now. So is that something that we can do tonight?
I'd be willing to do that. I did the same thing. I mean...
Now, this
staff-
is not to
staff's
say
gonna-
this is not to say we're prejudging, and I'm
No.
happy to hear from the hotels at the next meeting, and we can change things. It's not set in stone, but it would help to have a cleaner copy, because I have a lot of comments, a lot of minor things, some major. So
I just want to comment, I do think Sarah is right about the appeal process. If the hotel has the ability to appeal the staff decision, certainly the workers should. I mean, that's
Well, that gets into the very issue that John's talking
Yeah,
about,
right.
is do we want to dig into the substance of this tonight?
If we're delaying it, then I'd rather talk about it when it comes back.
But
I
you see
would
that-
too.
But you see, here's my hesitation in doing that, is that means then that if staff has to go back and do some more work based upon the questions or comments that we all raise, then that's going to delay implementation yet again while those things get worked out. I think it'd be better for staff to know what our concerns are now and either address those that are appropriate in open session. If there's some that border on closed session, we can deal with that. But they'll be in a much better position to bring something before us after talking with the hotels during this time that we can then be ready to vote on next time. So
Well-
that's my concern with waiting.
Councilmember Cassis, I think the union representatives have made their concerns very, very clear. And during the delay process, one would conjecture that the hotels would bring forward their problems. Then we have the whole package in front of us, and at that time could have a discussion. I don't quite know what, the staff isn't going to do anything until we have the final discussion
Yeah,
and
let
give
them work it out, and
direction.
then we won't have to go through as much, because I'm sure
That's
they're going to
right.
decipher.
I agree with you, Ken.
Would you call the roll on that motion?
Councilmember Bukowski.
Okay, what is the motion? I'm sorry.
To delay until the first meeting in February.
Yeah, aye.
Councilmember Fricke.
Aye.
Councilmember Cassis.
Aye.
Vice Mayor Atkin.
Aye.
Mayor Davis.
Aye. Moving back to the consent calendar.